Hello and welcome to the Law Lab. Here we dissect and unpack everything legal. My name is Risa Iris Ewonia, and today I'll be taking you through constitutional and statutory constraints on land ownership and use. Under Article 18(1) of the 1992 Constitution of Ghana, it states that every person has a right to own property either alone or in association with others. So this basically means that the right to own property in Ghana is guaranteed. Thus, you can decide to acquire any property by yourself or with other people. Article 18(2) also states that there is an injunction which has been placed against interference with privacy of home, property, and communications except by law and as are necessary for public safety, economic well-being, health, morals, or to prevent crimes. So Article 18(2) basically means that even though you have the right to own property as your own or on your own or with other people, Article 18(2) goes ahead to state that even if you do own the property on your own, it is subject to what will be necessary for the general public. So if the public will acquire the property to be used in a manner which could be either for public safety, economic well-being, health, morals, or to prevent crimes, you should know that your right to use your own property will not be enforced, or in that case, it will be infringed upon because your right to use a property is subject to the public interest or the general public. There are several instances in which the state has interfered with the enjoyment of property rights of persons in Ghana. The first part I'll talk about is compulsory acquisition, which is also known as the principle of eminent domain. This principle is based on sovereignty of the state, which is the power possessed by the state over all property within it. So even though Article 18 states that a person can own property on their own or with other people, there is compulsory acquisition, which basically means that even though you own the property, if your property is found within the state of Ghana, there are certain instances that the state will acquire your property or the state will need the property to use it in a manner that will benefit the people of Ghana. So Article 20 of our Constitution gives the instances within which the state can compulsorily acquire your land. Article 21 states that the compulsory acquisition should be one which is necessary for purposes of the public, and it can either be for public defense, safety, order, morality, health, development planning, or benefit. So these are the various B's within which the state will need or the state will compulsorily acquire your property. It is important to note that the state cannot take your property unless it is one that will benefit the general public. Article 21(b) also states that the necessity for the acquisition must be clearly stated so that it provides a reasonable explanation to anyone who suffers hardship as a result of the compulsory acquisition. So even if the state wants to acquire your land for an interest which will generally benefit the people of Ghana, they must give you an explanation for it so that you know that, this is the reason the state is intending to acquire my land. It is a necessary factor that the Constitution has imposed on the state to do when it intends to compulsorily acquire land. Even though the state may require your land for a public purpose, it must be characterized by the prompt and adequate payment of compensation to you. So if the state decides that it's intending to compulsorily acquire your land, the state must make sure that they will promptly and adequately pay the compensation of the land to you. So if they bring an evaluator and he values that the land should be about 100,000 cedis, when the state wants to compulsorily acquire land, the state must promptly pay that sum of money to you as the owner of the land. Where the owners of the land or the inhabitants of the land decide that they do not want to be compensated for the land, the state must move you to an alternative land with regard to your economic and social well-being. So maybe the land is situated at Kumasi and the state wants to compulsorily acquire it, and they intend to give money to you, but you decide that no, you do not want to move. So the state will then have to look for another place which has a similar socioeconomic well-being in relation to you and your land for you to move to that place. That is an alternative that the state or our constitution has provided in light of compulsory acquisition. However, in the event that any issue arises out of the compulsory acquisition, or you feel that you are being treated in a manner which is infringing on your rights as a person, Article 20 also grants the owners of the land or the inhabitants of the land the right to access a high court for their grievances to be heard. So it's important to know that it's the High Court that has jurisdiction to entertain matters in relation to compulsory acquisition. As I stated earlier, the land that has been compulsorily acquired must be used for the public interest. Now, public interest is basically an interest that inures the general public. And even though Article 20 Clause 5 states that if the state acquires the land for a public interest, it must be used for the purpose for which it was stated in the desire or in the agreement to compulsorily acquire your land. The case of Nick Probi Tetetru versus Attorney General has stated that public interest should not be limited to only the interest which was stated in the agreement. If it is such that even though it is used for another purpose, but that purpose is one that will benefit the public, it is still a public interest. So say if the state decides to, after compulsorily acquiring a land, the state decides to grant a portion of it to an investor who decides to build certain houses on the land and he rents it out to the public. The fact that he's renting out to the public will amount to a public interest because the public still has access to the property. Article 20 Clause 6, however, grants the right of option of reacquisition of the land, subject to refund, which could either be wholly or in part of the money that was given to you. But the refund must be commensurate with property value at the time of reacquisition. So if the state compulsorily acquires your land, and after using the land, or maybe not using it for an interest to benefit the public, and you decide to access the High Court, and the High Court agrees that indeed it is not being used for a manner that will benefit the public, and the state decides to sell it, you have the right of first option to reacquire the land. But that right can only be exercised by owners of the land or people who are inhabitant of the land. Even if you decide to reacquire the land, you must make sure to pay or refund the compensation that was given to you back to the state with an amount which is commensurate with property value at the time of reacquisition. In the case of Okujeto Ablakwa and another versus Attorney General and Obeche Bilamte, it was, however, stated that the provisions on compulsory acquisition, as highlighted under Article 20 of our Constitution, does not apply to lands which were acquired before the Constitution came to force. So always keep this provision in mind. It does not apply to lands which were compulsorily acquired prior to 1992. When a land has been compulsorily acquired by the state, the effect of it is that it extinguishes all rights and interests over the land. So if the land that was acquired as a family property, any interest anybody had in respect of that land has been extinguished. So a person cannot subsequently come and acquire any interest in land, which could either be by adverse possession or someone deciding to grant it to someone else, because it is only the state that has the interest in land. The case of Memuna Mudi versus Aintree explains this into detail, so I encourage all of you to read it. Another restriction which is placed on the rights of persons who own property in Ghana is a restriction on development of stool lands. In accordance with Article 267 of the 1992 Constitution, it states that any development in relation to stool lands must be subject to certification by the Regional Lands Commission. So Article 267 states that if you want to make any development on stool land, you need to be certified by the Regional Lands Commission to do so. But you also have the right to appeal to the High Court when the consent you need has been refused. There's also a restriction on collection and disbursement of stool land revenue. Article 2672 states that collection and disbursement of stool royalties, revenue, rents, dues, and others is a responsibility of the Office of Administrator of Stool Lands. So any royalties that are being incurred on stool lands must be collected by the Office of Administrator of Stool Lands. The office must ensure to open accounts for each stool and disburse it in accordance with Article 267 Clause 6. As a result, stools hold title just in name, but in actuality, they do not really have that much of an influence over the land. Article 267 Clause 5 also places a restriction on the type of interest that can be granted in relation to land. That article states that there cannot be any creation of a freehold interest from stool lands in Ghana. So if you decide to create a freehold interest, which in our previous videos I stated that is a perpetual interest, that interest has been proscribed. So as of 1992, nobody can create a freehold interest within the country. Article 266 also states that non-Ghanaians cannot acquire freehold interest in Ghana. So if you are not a citizen of Ghana, you cannot expect to acquire a freehold interest. Besides, citizens of Ghana have even been proscribed from acquiring this interest. So it would be absurd if foreigners were able to acquire that interest. Article 267 Clause 3 to 5 also places certain restrictions in relation to interest in land in Ghana. These provisions of the 1992 Constitution states that non-Ghanaians, who are basically foreigners, can only acquire 50 years leasehold in Ghana. And if those citizens had an interest which was indeterminable or it was a freehold interest, it has been converted to a leasehold interest not more than 15 years, as of the 22nd of August 1969. Another restriction in relation to land use in Ghana is found in relation to mineral rights. So Article 257 Clause 6 states that every mineral in its natural state is vested in the President on behalf and in trust for the people of Ghana. So any mineral that you find on your land does not belong to you. In our previous videos, I made mention of the fact that even though you own the land and anything found below it or attached to it, there's a restriction to this which is in our constitution. And that is what I just explained. If you discover any mineral on your land, it does not belong to you. It belongs to the Republic, and that mineral has been vested in the President for and on behalf of the people of Ghana. So the President is holding it in trust. However, Article 268 says that when it comes to granting of mineral rights or granting of concessions in relation to these minerals that have been discovered on land, it is subject to the ratification by Parliament. So these are the various restrictions that have been placed on the use of land in Ghana. By way of recap, I spoke about compulsory acquisition, which is basically when a state can compulsorily acquire land for public interest. However, if the state decides to compulsorily acquire the land, you are entitled to be compensated. Or even if you are not compensated, you should be moved to an alternative land which is suitable to your socioeconomic well-being. Also, if you have any grievances in relation to the compulsory acquisition, you are entitled to seek redress in the High Court as per Article 20 of our Constitution. I also spoke about restrictions that have been placed in relation to interest in Ghana, which basically states that no freehold interest can be created. And if you're a foreigner, the highest interest you can have in land is a leasehold interest, which is not even more than 50 years. I made mention of mineral rights and the restriction that's been placed on it, which is basically that every mineral that is found in Ghana is the property of the Republic, and it is vested in the President, who holds it in trust for and on behalf of the people of Ghana. Thank you for joining me on this wonderful session. I hope you understood everything we have discussed today. Kindly like, comment, and share our videos to your friends so they can also learn about it. Have a lovely day.